Practice and Disclosure section. An agent must account for all money and property that comes into his or her possession, such as earnest money deposits. State laws regulate when the brokerage firm must enter the earnest money into an escrow or trust account. An escrow account is for other people's money. In a real estate transaction, that would include the earnest money check. The broker is not allowed to commingle or place the check into a business or personal account. Conversion, which is also illegal, is the act of using the earnest money checks. For example, taking the money to gamble in Vegas. The duty to work with care and skill is different depending on who your client is. If the broker's client is the seller, the broker must properly represent the property, establish a correct list price, warn a seller of tax consequences, and make an effort to find a buyer. The agent is obligated to follow the legal instructions of the client. For example, an agent cannot put a for sale sign in the front yard if the seller does not want one. However, should the seller not want to sell the property to a minority, which is illegal, the agent should refuse the listing. An agent's loyalty to a seller means seeking offers for price and terms acceptable to the seller, explaining offers to a client, disclosing when the broker is purchasing the property for his or her own account, and representing only the interest of the client. If a seller has accepted an offer, an agent does not have to seek additional offers unless instructed to do so by the client. An agent is required to present offers in a timely manner, as well as present all required forms for the transaction. An agent must disclose any facts that would affect the principal's decision to accept or reject an offer or to purchase property. Examples of such facts include, but are not limited to, disclosing all offers to the seller, if the buyer does not qualify for a loan, if the buyer is willing to offer more if the seller rejects an offer, or if a buyer intends to resell the property. When a licensee is representing the buyer, typically it is his or her duty to find a suitable property, evaluate property values, and seek financing alternatives. When representing a purchaser, an agent must seek property at a price acceptable to the purchaser and present any offers in a timely manner. A licensee does not breach any agreement or duties to the purchaser by showing the same properties to other purchasers. The licensee cannot accept compensation from a broker who represents a seller without the knowledge and consent of the buyer. If an agent is representing a buyer, he or she must disclose all the known property defects, how long the property has been on the market, unsuitable contract provisions and financing, and help establish an offering price. A licensee is not required to discover latent or hidden defects. A latent defect is a defect not readily seen by anyone looking. For example, a crack in the foundation. A licensee is not required to address matters beyond the scope of his or her knowledge, nor is a licensee responsible to verify the statements made by the seller unless the information provided is questionable. Stigmatized property is a term used in the real estate business which describes possible detrimental features of a property or home, all the result of unfortunate occurrences. These can include murder, suicide, or even the belief that a house may be haunted. Puffing is an exaggeration of a fact. Many agents puff when dealing with third parties. Puffing is legal as long as the statements are not fraudulent. We have all heard agents say, "Wow, this is the greatest house I have ever seen in my life." It's not lying, but it's close. An agent must not misrepresent facts, commit fraud, or be negligent. Misrepresentation is a false or misleading statement or assertion of a material fact with the intent of deceiving someone into taking a course of action he would not otherwise normally pursue. A licensee may be disciplined for misrepresentation even if the misrepresentation did not result in a loss to the principal. For example, if a party has been told a property has been zoned multifamily when in fact it is zoned single family, the property has been misrepresented. There are different types of fraud: actual fraud, constructive fraud, and negative fraud. Actual fraud is a deliberate misrepresentation or a representation made in reckless disregard of its truth or falsity, the suppression of truth, a promise made without any intention to perform it, or any other act intended to deceive. Negative fraud is the act of not disclosing a material fact to somebody, thereby inducing him or her to enter into a contractual situation that causes him or her damage or loss. Constructive fraud is a breach of duty without any fraudulent intent, such as when a person in a fiduciary capacity takes advantage of another person by misleading them to a prejudiced position. This is also known as passive fraud. Negligence is the failure to perform a duty or failure to exercise a standard of care that a reasonably prudent person would have exercised in a similar situation. Negligence is typically due to a lack of time, forgetfulness, or just plain laziness. For example, if an agent is listing a property and there is a question regarding the zoning, the agent should contact the zoning office. Usually this can be determined by a phone call or checking the website. If the agent knew that there was a question regarding the zoning of a property and did nothing, the agent could be found guilty of negligence. Fraud may take the form of either misrepresentation or negligence. In either case, the agent may be civilly liable for damages incurred by the purchaser on account of the misrepresentation, or the agent may be subject to disciplinary action against the agent's license. The owner may be vicariously liable in damages for the agent's misrepresentations, even where the owner was not the source of the erroneous information conveyed to the agent. This concludes the section on practice and disclosure.